So, good afternoon, everybody. In this video, I would like to talk about the Article 19 of the CIG, where it states that the reply to an offer that includes changes or additions is considered as a rejection of the original offer and becomes a counteroffer. And some commentaries that I would like to share with you today that was found before. The first one would be from the Schlechtheim and Schwessner, and they highlight that Article 19 of the CIG allows for acceptance of an offer even with the immaterial alteration, diverging from the common law strict mirror image rule. And they noted that, however, that applying this provision is complex, particularly in these cases involving standard forms and the long-term agreements. With respect to second commentary that I found, it was given by Franco Ferrari, and here he explains the provisional regions comparing into mirror image rule, like as the Schwessner and the Schlechtheim as well, and he discusses the exceptions of the provisions 2 and 3 of this article, which allow for acceptance with the immaterial alteration. He emphasizes that determining whether an acceptance materially alters the offer requires the careful consideration of the specific circumstances of each case. And with regard to last commentaries, and would be from the Secretariat of the CIG, and he explains that the late acceptance can be still valid if the offeror promptly informs the acceptor of its validity, different from the common counteroffer theory, where the offeror's notice become like the acceptance. So what about cases? The first case happened in the Austrian Supreme Court in the March of the 1997, and here the court remanded the case to the Court of First Instance to clarify whether the seller's reply to the buyer's offer was sufficiently. And here the reply of the buyer must be definite under the provision 1 of Article 14 of the CIG, and if the alteration in the offer were material under the CIG provision 2 of the Article 19 and the provision 3 of the Article 19 of the CIG. And here the case emphasizes the importance of the Article 19 in determining whether changes in the terms of an offer, particularly those that favor the other party, are considered material and require express acceptance. Another case happened in the South Korea in the Busan District Court. And here the court determined that defendant, despite its claims, was actual party to the sales contract and was obligated to pay the price by opening a letter credit due to established practices and the continuous transactional relationships under CIG. And the court emphasized the importance of the Article 19 in rejecting the plaintiff's claim for two other contracts as the substantial alteration of the terms indicated in the purchase orders meant there was no final meeting of the minds, and viewing the orders as a preliminary documents. And the last case that I would like to talk about here would be in France in the Court of Cassation, where the parties X versus LGDD, and it happened in the 2014, where the Court of Cassation dismissed the appeal, affirming the Court of Appeal of Rennes, their decision that the sale contract had been formed despite differences in the quantity of paving stones as a presumption of the material alteration under provision 3 of the Article 19 of the CIG. And the Article 19 is crucial here to establish that the presumption of material alteration can be rebutted with the sufficient evidence and like allowing a contract to be considered valid despite the modification. So thank you for listening to me. That was a pleasure, and see you in the next videos.